Good morning once again. I hope you're having a lovely spring. The weather in Cape Town is a bit cold, nonetheless. We are in the office and we are ready to start this webinar and hopefully we can benefit from it. My name is Mohammed Abduroaf. I'm an advocate in Cape Town and today's topic, relocation with your minor child. What do you need to know? Part 2. For those of you that did not watch the previous video, I think it was on Wednesday, whereby I dealt with the issue concerning relocation, general issues regarding it. What is relocation? Why would somebody want to relocate? What does the law look at? And so on. Quite general. I had quite a few comments after that. I could not deal with those comments because it came after it wasn't live. And generally, most of those comments related to what should a person outline in your application to court should an application for relocation be opposed. So basically, you have applied or you want to relocate to a different country with your minor child, and the other parent who has to give consent does not want to give consent. What do you do under those circumstances? I have mentioned you have to approach the court. Now the question basically is, what exactly do you outline in your application for relocation? Okay, so that's a topic today that deals with part 2. Please watch part 1 if you want some more information regarding relocation generally. A quick recap on the issue concerning relocation. Please remember that a mother would always have guardianship rights over a minor child. So therefore, her consent would always be required unless a court of law took that specific consent away or rights away of guardianship. The father, on the other hand, if the father was married to the mother or is married to the mother, automatically has guardianship rights over the minor child. If the father is not married to the minor child, by default, it does not mean he does not have parental rights. If he is involved in the child's life, pay child support, and is there, automatically he would have guardianship rights over the minor child. However, if he was never involved in the child's life, he only knows who the child is, etc., he would not have guardianship rights. The problem that may arise is if you approach the Department of Home Affairs and apply for passports or border control and so on, they will see, okay, on the birth certificate, the father's details on there, where is his consent? Despite he never having been involved in the child's life, they would require his consent. And that is one reason why you approach the court. Other challenges that you may have is when you go overseas, they might ask you, where's the father's consent for the enrollment to a school, for medical procedures, and so on. Nonetheless, this topic deals with that. So first and foremost, you wish to relocate, you have very good reasons for that, according to you. You've asked the other parent, please give me consent for the relocation of the minor child for you to move overseas and live overseas with a minor child. As mentioned previously, if you would like to travel on your own, you're welcome to do so, but the problem here is we have a child where there are parents that both have guardianship rights over the minor child, and their consent obviously would be required. You'll approach the court, the High Court, and ultimately you'd want to ask the court for the following relief, in no particular order. Number one, that the consent of the other parent is not required for the minor child, firstly, to apply for a passport. If the child has a passport, then that obviously is not a request to the court. The second relief you'd ask the court would be that the other parent consent is not required for the relocation of the minor child to that specific country you intend to go to. For example, let's say Switzerland. Because in terms of South African law, Section 18 of the Children's Act, both parents' consent is required for the minor child to leave the Republic of South Africa. So that's the second leg. You'll ask for the consent to be dispensed with regarding the relocation. The third relief, which many lawyers may not include, some may include, some may not include it, or some might not think of it, would be that when it comes to certain decisions, whilst you are overseas, for example, the enrollment into a school, the application for a passport should be there because the passport might expire soon, medical procedures, etc. And under those circumstances, consent of the other parent is not required. So that your relocation will be a smooth relocation. You do not all the time have to obtain consent from the party in South Africa all the time. If it's workable, maybe you should, but there is a dispute in place here. You are approaching the High Court for relief. Obviously, the other parent living in South Africa has an issue with the relocation. The court might override his consent, but now the court says his consent is not required. Doesn't mean automatically he would accept that. And once you are overseas, he will then comply. I doubt that. The fourth leg, it's an important leg, and many people do not think about this. This leg is what type of contact would the parent remaining in South Africa have with a minor child should the minor child relocate to the country. So where am I going to with this? At present, let us use an example where the mother is relocating with a minor child. The father will be remaining in South Africa. The father sees a minor child every second weekend, half school holidays, or face-to-face. He does not necessarily have video contact because he sees the child maybe midweek contact as well, every Wednesday or Thursday. So that's fine. So he sees the child most of the time, half holidays, Christmas, Father's Day, Mother's Day, children's birthdays, their birthdays, religious days, and so on. So that's fine. But what happens? Now the child will be relocating with the mother to Switzerland. He will not have that type of contact any longer. Every second weekend, half school holidays. It's impossible. It won't happen unless he flies down every weekend or the child flies down every weekend, every second weekend. So we know that that will not happen. Now we have to find an alternative mechanism, an alternative type of contact that will be appropriate under the circumstances. And of course, it would be a video contact on a regular basis at a convenient time. Some countries, many countries, for matter of fact, has a different time zone. So it might be 7 o'clock in the evening in South Africa, but it might be 2 o'clock in the morning in the other country, or vice versa. Problems may arise where that is concerned. It means that the parent remaining in South Africa would have to wake up every morning at 2 o'clock in order to have a video conference with a minor child before the minor child goes to school. Or stay awake till late the evening in order to have a conference with a minor child when the minor child comes home from school, and so on. So those are challenges which we have to look at and work around it. Now that we have identified video contact, telephonic contact, WhatsApp contact, and so on, we need to now deal with the issue concerning physical contact. When did physical contact actually take place? Are we stipulating in the order that the minor child should fly down to South Africa at least once a year? If it's practical, if it's affordable, etc., it's workable? Or if the parent remaining in South Africa wants to visit a minor child in Switzerland, should that parent have contact anytime, or should it be during an arranged time, for example, the December holidays or the mid-year holidays, and so on? These things need to be unpacked and worked out, because we do not want to have a situation where the court authorizes the relocation of the minor child, but the parent living in South Africa has no rights, no rights, but no way to exercise any contact to the minor child. So, nonetheless, you need to think about that. Think about your rights of wanting to relocate overseas, but also think of the rights which the parent living in South Africa would have regarding the minor child should you relocate. The court would want to know this. The family advocate would want to know this. Everybody wants to know this. How are we to make this thing work? It has to work, because a minor child might benefit from relocating to overseas, but the minor child could also be detrimentally affected by not having contact with the parent. So we're not saying that the relocation should not take place, but before the relocation takes place, let us first sort out the care and contact issue. The same with a divorce. The law is not saying parents cannot get divorced. If the marriage has broken down, that should happen. They should get divorced. However, before the court divorces them, the court want to make sure that has the care and contact and the maintenance arrangements been resolved. And the court makes one final order. Of course, there are exceptions and so on. Okay, so that is a notice of motion. They call it a notice of motion. It's basically what you want the court to grant you. Stipulating number one, as I mentioned earlier on, that consent for a passport should be dispensed with. Relocation, the same thing. Guardianship issues should be overseas. You will have sole guardianship rights, for example, medical and schooling, and care and contact arrangement that will be in place should you relocate, video contact, telephonic contact, physical contact, whatever the case may be. So that's what you want. Then what do you stipulate in your affidavit? With these type of applications in court, you do not come to court and give oral evidence, at least in the High Court. In the Children's Court, you may do that, depending upon the nature of the children's matter. But in the High Court, you provide all the information in affidavit format. You'll have to obviously explain to the court, firstly, who are you? Where do you live? Where do you work? Who is the other party, the respondent, the father, in our example, going to Switzerland? Who is he? What does he do? Where does he work? The relationship between you and the father. Were you married? Were you divorced? Were you in a relationship? Whatever the case may be. So we understand the dynamics of what we are dealing here with. Then you go further and you need to now explain to the court who the minor child is, the subject of this application, who the minor child is. Where is the minor child living? Is the minor child in boarding school? Is the minor child living with you? Is it living with your family? Whatever the case may be. What contact arrangements are there in place between the other party and the minor child? Does the minor child have any medical issues? Sometimes it is a case. It's relevant to the application. The school the minor child attends, grade, etc. So you provide a bit of a detail regarding the minor child. Then you explain to the court what your application is about. You want to relocate. Why do you want to relocate? You need to unpack that for better life for you, educational, medical, getting married to somebody there, etc. If your application is urgent and you have to relocate quite soon, then you have to explain why the application is urgent. You can explain, schools are starting soon, you've got a job offer all of a sudden, you need to move. If you do not take the job offer now, your life will be very hard, and so on. So that's something which you have to obviously look at and apply your mind to. Going forward, if the court ultimately provides you with a relocation, a consent to relocate, what type of life will the minor child have there? Are there schools available? Are there medical facilities available? Are the accommodation? What type of work will you be doing that side? So the court would like to know all the specific relevant information. Okay, so that's very important. You need to outline and unpack that. You need to deal with the current care and contact arrangement the child has with a parent living in South Africa. What are the dynamics? Is there a court order? Is there a divorce order? Whatever the case may be. Ultimately, you have to convince the court why it would be in the minor child's best interest for the relocation to take place. Now, having said what I have said now, everything. If you have supporting documentation, for example, a document stipulating that I've tried to enroll the child to another school in Switzerland, however, they will only accept the application once I can give them a strong answer that I will be relocating, and so on. So you have the supporting documentation. You have done your homework. You have employment documentation showing that once you arrive in Switzerland, you will have a job, you will have accommodation, and so on. You'll have to argue to the court when you're arguing what is in the minor child's best interest, that the child needs to relocate with you. The child cannot stay in South Africa. The child cannot remain in South Africa because the other parent cannot care for the minor child. Or the other parent can care for the minor child, however, not as well as I can. And holistically, if you look at all the facts, it makes more sense for the minor child to relocate with me as opposed to staying in South Africa. If you are going to an extremely dangerous country, there are no facilities for minor children, then of course it makes more sense for the minor child to remain with that parent, with a secondary caregiver or the other parent living in South Africa to care for the minor child, so that you can go overseas and do what you have to do that side. It will not be in a minor child's best interest. But if the opposite applies, you need to convince the court regarding that. So that's the long and the short of it. That specific documentation gets served on the other parent, on the respondent. He or she would get an opportunity to respond and try to convince the court why his consent should be required, why he's allowed to refuse consent, or why the minor children should remain in South Africa, whatever the case may be. And he'll give you good reasons. He will respond to your comments, your allegations. You are saying Switzerland is a very good country educational-wise. Maybe it is, maybe it's not. Maybe for your specific child, maybe you have a special need child. Maybe the medical professionals in South Africa stipulates, no, the best school for the minor child is the specific school. Changes to the minor child now would be detrimental to the minor child. Maybe the child is a matric, 17 years old, whatever the case may be. So those are the things which you want to obviously show the court. And you, of course, as an applicant, the person who is relocating, would get an opportunity to respond to that as well. The court may require, and you might be smart enough to ask the court for an order that the Office of the Family Advocate may investigate into this matter, consult with the child, consult with the parents, etc., and decide and advise the court what is in the minor child's best interest. So the long and the short of the matter is your application must be well thought of. It must not be half-baked. It needs to deal with all the aspects, because it's not a normal, simple application whereby mom and dad separated, mom lives in this suburb and the father lives in that suburb, and now they have a problem how to have contact. Quite simple. The court would easily resolve that. It shouldn't be that hard. Here we're dealing with a scenario regarding relocation, where the minor child will be taken out of the country, away from the parent living in South Africa, and get cared for by the other parent. Nonetheless, that's our webinar today. I do not see any questions. I'm glad. Generally, these questions comes later on when people watch this video at night. Nonetheless, have a lovely day, and thank you for joining me on this webinar. Bye-bye.